Hi, Sean.
How are you?
Good. How are you? Long time no see.
It has been, but it's still good to see you.
Same here. Okay. We don't have a lot of attendance, but this is taped and it is available for people to watch on our website.
I won't flip anybody off.
That'll be unusual.
Oh,
And don't tell about me either.
I won't. Look, that goes both ways.
Right.
Stand by. We'll begin started shortly.
Good evening. This is the Intergovernmental Committee Meeting of June 2nd, 2021. This evening we have my name is Linda Gray. I'm the councilperson from the 1st District and I'm the chair of this committee. I think, could other committee members introduce themselves?
Yes, Shanae Darby, 2nd District. I'm the co-chair for Intergovernmental Committee.
Any other committee members? Any other council members in attendance? Okay, then.
Yes, Councilwoman Brigida Fields here.
Thank you very much.
You're welcome.
Anyone else? Well, I will acknowledge you as you enter the meeting if you just put it on chat. Okay, this evening, we're going to have an overview of current landlord-tenant guidelines for evictions. And who do we have to speak to this matter?
Madam Chair, I have a question. I'm sorry. Do we have enough people for a committee meeting?
No, but since we're not voting on anything, Daniel should be here. I put that in the chat. Excuse me, we're doing administrative work here. I had put it in the chat that since nothing is being voted on tonight, we could proceed even without a quorum. And I haven't gotten a response, so.
I was just wondering. I'm new to this. I was just wondering. I didn't know.
Thank you. I wondered about that too, but thank you. Okay. For everyone that's listening in the public and also for the Honorable Sean McCormick, that was just a little housekeeping here. So you can start.
Okay, ladies, thank you very much for having me today. My name's Sean McCormick. I'm the Deputy Chief Magistrate here in Newcastle County. We hear a variety of cases here within the Justice of the Peace Courts. For our purposes tonight, I think the most talked about is going to be landlord-tenant cases. As you're aware, with the COVID pandemic, landlord-tenant cases are a hot button issue. People don't want to necessarily see people get evicted because if they become homeless, there's a significant possibility they could help spread the disease to people that might not have the medical wherewithal to fight it off or otherwise seek help. On any given year, I can tell you that JP Court 13, which is responsible for civil filings in Newcastle County, here's about almost 16,000 civil cases of some nature, landlord tenant debts, replevants, a variety of cases. Approximately 8,000 or slightly more than 8,000 of those are landlord tenant cases. This year, I can tell you, post July 1st of last year, our filings are down to 4,178, and that was as of Friday. So landlord-tenant cases have fallen off by half. That may be a very good thing, obviously. The federal government has poured a great deal of money into pandemic assistance. One of the things that they have done is pump money into the various state housing authorities. That money will pay up to 15 months of rent for people that are having financial difficulty that stems from the pandemic. As I'm sure you know, a lot of people lost their jobs last summer or otherwise were not in a position to pay their rent. I think actually we figured out that approximately 1,500 and change of those 4,100 cases have actually sought that type of assistance and thereby avoided eviction. Normally, of the 8,000 odd landlord-tenant cases are filed in a year, more than 1,000 end up in evictions. With the pandemic and the various orders of protection that the CDC and Governor Carney put out, we have from July 1st to date only evicted 124 people. And probably about 40 of them were people who had cases filed before the pandemic started last year and before we shut down on March 13th of 2020. So it is a very low number. We're very fortunate that there is significant assets out there that can help people in this time of need. I think you ladies are probably aware that the CDC has issued a stay on evictions until such time as the pandemic is significantly over. Basically, it says in so many words that if you've made the best efforts to obtain government assistance, are unable to pay your rent because of some COVID-19 related issue, and if not paying your rent or getting evicted will make you homeless, then the CDC has ordered that any eviction would be stayed except for non-monetary reasons. Governor Carney, back on July 1st, 2020, issued as part of his pandemic order, an order saying that evictions could not take place unless they were done in the interest of justice. And the question is, what does that mean? Well, I'll let you in on a little secret. That's something we try to keep vague. Interest of justice is something that judges pull out of their pocket when they don't have anything else to lean on and say, well, it's because I think it's in the interest of justice. This forced us to define it somewhat.
I thought no secrets.
It's not no secret.
No, I thought you weren't going to tell any secrets.
Well, the governor made me do it, in effect. We've actually come up with a definition. Interest of justice is a legal proceeding that refers generally to the standard of fairness and equity. The standard is applied when a judge has discretion in making a ruling, and the term is very subjective and will vary based upon the facts and circumstances presented in an individual case. So in short, for those 124 evictions that did take place, in each and every case, a judge had to weigh the factors and determine if it was in the interest of justice to evict that person. I think, as you can see from the numbers, 124 as opposed to over 1,000 in a given year, the standard has been pretty strictly upheld.
Excuse me a second, Judge McCormick. I want to acknowledge Ernest Congo, our president, as being in the meeting. You can proceed, sorry.
Oh, quite all right. I'm glad that you can join us. Thank you. The real question everybody kind of has is, when are things going to change? And the answer is, I really don't know. Governor Carney plays his cards pretty close to his vest. We don't know when he's going to change the circumstances under which eviction could take place. So long as federal funds are still out there to help pay rent, and so long as there's a need, sincerely, we hope that he would leave it in place somewhat longer. But it really is going to depend. And I think it's going to depend on how quickly, in short, our economy is back up and running and how quickly people are actually vaccinated as to COVID-19.
Okay, I don't see any questions, but I was going to say, isn't there some type of negotiation process prior to any type of eviction hearing?
Yes, part of the governor's order, and something that we have maintained, is that once a case was filed, before we would go forward in a trial proceeding, you had to engage in mediation. And that was actually very important, because with mediation, it made people look at options that they didn't know they had, like applying for federal funds or other assistance. We started off in person, a variety of magistrates and then some attorneys private attorneys who just agreed to do it on a voluntary basis oversaw the mediation. One magistrate in particular, Peter Burkett, was very successful in a variety of cases. Right now, we're doing the mediation on an online platform. It requires you to email back and forth and explore some of the options that are available to you. And you have to do that before you can even, before we will allow you to proceed forward on a landlord-tenant filing. Councilman Gray, I'm sorry, I didn't hear you.
I'm sorry, I'm muted. I was asking if there were any questions from any of the council members. I don't see any hands. Oh, that's good, Sean, then.
I wowed and dazzled him with numbers.
Right. WITN, are there any is there any public that has a question?
There aren't any hands up.
Okay, thank you very much. So could you do a summary of the process if someone is getting evicted for us? Just basics.
Right now, when we opened up last year, we were about 6 months behind. We've been playing catch up right now. Right now, from a case to be filed until it actually gets to court is taking about 10 weeks. Pre-COVID, it was standard that we would get into 4 to 5 weeks. So we are still substantially behind, but a landlord would file a case. We would set it up for mediation, hope the mediation is successful. If mediation was not successful, we would still try to further mediate as the case came before the bar. Again, they don't always realize some of the options that are available to them. Once the case is heard, the case would be heard just like this. We're using the Zoom platform or requiring people to present themselves to the court in this fashion. If they don't have the technology, we actually have some offices set up in the Justice of the Peace Courts where they can come into our lobby and go into that office and connect virtually. One of our clerks will set them up. Ultimately, the judge hears the case. If the case goes against the tenant, then the question that has to be raised is twofold. Have you filed a CDC declaration with your landlord? And or to the landlord, why is it in the interest of justice that this person be evicted? And they've got to come up with a substantial reason. And the reason's got to be other than money, simply because there's other means to get the money out there right now. If they can answer that question, regardless of how they answer that question, the tenant does still have the right to evict. So does the landlord if they don't prevail. That right extends for 5 business days. If they appeal, and it's scheduled for a 3-judge panel that I chair. Right now, those are taking about a month to 6 weeks to get on the docket. If at the end of the appeal hearing they still lose, then ultimately, if the interest of justice exists, they could be evicted. The eviction process requires the landlord to seek it. They have a window of opportunity to do so. It's 30 days. After which my constables will serve people and give them usually at least a week's notice to know that they're going to be coming to change the locks at some point.
Okay, thank you. I think that's very thorough. And we still don't have, we do have a question from Councilwoman Darby. Councilwoman?
Yes, thank you. I don't specifically have a question, but this made me think of on the state level, there's a legislation fighting for the right to counsel, which will protect renters, meaning that low-income tenants will be guaranteed access to a lawyer for their eviction proceedings. And I think that is so important for Wilmington, because each year, well, prior to like COVID, there were about, from the data that I have read, like 1,800 evictions, and most were from Wilmington in the state. And 84% of those were represented by an attorney or a Form 50 agent, which is a non-attorney. It's a Form 50 agent. It's a special rule only for landlords, right? So landlords go in there represented, the majority of them, 84% went and represented. In comparison, less than 5%, that number just threw me off when they told me that. 5% of tenants are representative or have a sense of lawyer, and there is not a special rule for tenants. So it's not a fair balancing act. for tenants. It's not fair for them to not have the same type of special rules or not being able to have an attorney or a lawyer represent them. And then I just really think with the effects of COVID, we need to set up a plan and support the state for right to counsel to protect renters here in Wilmington, because the majority of our city consists of renters, right? And it is projected that evictions will increase once we're out of COVID, and allowing legal representation is just an effective tool for me, I think, of to prevent evictions and homelessness. And in New York City, they were the first to pass the right to counsel legislation. And then I know they did it in Newark, New Jersey, Philly, Cleveland, San Francisco. They all passed the right to counsel either during COVID or before COVID. So I just think it's really important, as we're having this conversation, that people are aware that this conversation is happening, and it's not fair balancing act when you walk in there as a tenant versus when you are a landlord. Not all the time, but the most of the time. 84% of landlords are represented, and they have a special rule where less than 5% of tenants are not represented, and they do not have a special rule to have a non-attorney person represent them in court. So I just want to make sure that was known, but I really didn't have any questions, but I also wanted to make sure that people understood that and were aware of that.
Thank you.
Actually, I have a copy of the legislation here, actually, Councilwoman.
Okay.
Yes.
But, maybe Judge McCormick, you can explain. I thought everyone has the right to an attorney, and there are legal aid and public defenders. So I'm not really understanding why they don't seek attorneys in landlord-tenant cases, the tenant.
Honestly, I think it's because a lot of people that are below the poverty line don't recognize or realize that there are assets available to them. And you're absolutely right. Whether it be Community Legal Aid or Delaware Volunteer Legal Services, or the Legal Services Corporation of Delaware, all of those agencies will represent people who are below the poverty line for free, effectively.
Right.
But their resources are strained, and quite frankly, a lot of people don't realize that that is an option for them. That if they go seek an attorney, they might do better. The vast majority of people who are represented do better in their case than those that are not represented. That's absolutely correct, Councilperson Darby. With the Form 50 agent, I tell you, that is actually not just landlord-tenant. That's court-wide for the JP Court. It's a special rule that allows a business representative to represent their business interest, because we're the small claims court. To hire a lawyer usually would cost more than the debt is worth collecting, and that's why it's allowed. But it does mean that a lot of landlords who are small businessmen either employ an agent or represent themselves in that capacity.
Okay. Explanation, yes. Well, if no one else has any other questions, I have a question that's off of the landlord-tenant, but with JP Court. We had someone to present the rules and the procedures for dogs, for animal control. And I understand that JP Court handles the vicious dog cases, but you only do it in Dover. Is that case? Can somebody have it transferred to Wilmington? That was a concern of mine.
Right now, they're only doing it in Dover. I would agree that we're the smallest county, but the most populated. It stands to reason we're going to have more dogs up here than they do down there. But that would be a question for the chief magistrate as to why we can't have vicious dog hearings up here. Okay. I do know that since in 2013, when formally, as I think you all know, it was the SPCA was contracted by the county or by the city of Wilmington to handle animal control. And slowly those agencies, which were all nonprofits, got out of that part of the business. The state created a new office, and it's under the Division of Health and Social Services, actually, to act as animal control agents. And they'll come up, but yeah, the hearings are all in Dover right now. Part of it is the chief magistrate wanted to create a small group of magistrates, 2 or 3, that would hear these cases and really gain some expertise on what does or doesn't make an animal deemed vicious in nature.
Right, but for regular suing people for dog bites and other destructions by an animal, that can be heard in any JP court?
If it were damage or destruction, that could be any JP court that stemmed out of an incident. If it were medical bills, yeah. If it was something that had to do with punitive damages, pain, suffering, that'd have to be the Superior Court of Court Common Pleas. But that could be in any county.
But the medical could be in JP, but if you want beyond like pain and suffering and inconvenience, you have to go to Superior. Okay, thank you. I'm very
Yeah,
clear.
the determination they're making in Dover specifically is whether the animal is vicious or not, and if
Right.
it should be put down or be returned to the owner with conditions.
Right, thank you very much.
All right.
Okay, last call for questions. Any questions from council members? And I understand there's no public with questions. So I thank you, Judge McCormick. I think it was a very thorough presentation, and I really appreciate you accepting this invitation.
Anytime. I appreciate your time. I hope you ladies have a good night.
Thank you. Same to you. Okay. The next thing on the agenda is a resolution to support, let me see, to support Senate Bill 149 to repeal Delaware Law Enforcement Bill of Rights and amend Title 11 of Delaware Code. And I'll let the presenting councilwoman, which is Councilwoman Shanae Darby, it is her resolution. Councilwoman Darby?
Yes, thank you, Chair President. So I will be presenting a resolution in support of the revisions on this that needs to happen on the state board to Leo board, which is the Law Enforcement Bill of Rights. So I will read the resolution. Whereas for more than 50 years, American police officers have been afforded a special layer of employee protection when faced with investigations for official misconduct. This special layer of protection is commonly referred to as the Law Enforcement Officers Bill of Rights, Leo Board. And whereas these protections currently exist within 14 states, including the state of Delaware, each state has different statutes. The protections granted to police officers are more specific than those provided to other public employees in federal, state, or local civil service laws. And whereas the Law Enforcement Bill of Rights is intended to protect American law enforcement personnel from investigations and prosecutions arising from conduct during official performance of their duties, and provide them with additional privileges based on due process than those normally provided to other citizens or professional fields. And whereas the Delaware General Assembly passed legislation entitled Title 11 Crimes and Criminal Procedures, Victims of Crimes, Chapter 92, Law Enforcement Officers Bill of Rights in 1974, incorporating the law into Delaware State Code. And whereas due to a number of provisions in the Delaware Law Enforcement Officers Bill of Rights for police departments and towns throughout the state, including the city of Wilmington, there is a lack of transparency and accountability for police officers and departments. It has become an issue for many in the community. These police officers need to be charged to serve and protect. And whereas the Delaware Leo Board includes provisions that prevent public access to officers and police departments' reports on deadly use of force incidents, including when guns are fired, and prevents access by legal counsel of defendants to receive internal affairs investigation records of law enforcement officers accused of wrongdoing. It also ensures that all records compiled as a result of an investigation or disciplinary grievance procedures remain confidential and shall not be released to the public, and that complaints made by other citizens on police actions are confidential or are not to be released to the public. Police departments cannot publicly acknowledge that an officer is under investigation or that charges are dropped, nor publicly acknowledge that the investigation ever took place or reveal the nature of the complaint. And whereas in Delaware, based on a report conducted by Y from 2005 to 2020, Delaware police have shot 56 people, killing 30 of them. Nearly half of those shot, 48% were Black in a state whose population is only 22%, demonstrating a clear overrepresentation of Blacks and victims of police shootings. And whereas no officers in Delaware have been charged with the crime, even in instances where their use of deadly force has been questioned by state prosecutors, members of the public, and lawyers for the people shot. There are compelling reasons to be concerned that the Law Enforcement Officers Bill of Rights may be providing protections that are not warranted in a democratic society that is based on the rule of law. Now, therefore, be it resolved by the Wilmington City Council that this council strongly recommends that the Delaware General Assembly supports Senate Bill 149 to repeal the Delaware Law Enforcement's Bill of Rights and amend Title 11 of the Delaware Code to establish greater transparency and accountability for police officers and police departments with all citizens in Wilmington and in Delaware without respect to race, ethnicity, religion, gender, social, economic status, geographic location, and or prior criminal records. So that is the resolution, Chair, President.
Okay, do we have any comments? Would anyone like to make any comments about this resolution? Well, I would like to, I think this is excellent. I definitely support it. And there is there's an act in the federal government. It's HR 1280, which incorporates some of the same things that our legislators have advocated or are trying to get passed. It passed the House on March 3rd of 2021, and they give it a 69% of passing the Senate, but we should support it. I'm pretty sure our senators will support it, but it's the rest of them. But it's similar to this. So I'm happy that our legislator has done this, and I'm very supportive. President Congo?
Thank you, Madam Chair. I'd like to be added as a co-sponsor. This is an excellent piece. It's been a long time coming. So I definitely want to be a co-sponsor. Thank you.
You're welcome. I think your name is already on there as a co-sponsor.
Okay. All right. Thank you.
Okay. Any other comments? Is there anyone from the public, WITN? No?
Yes, we have 3 members of the public. We have Cheyenne Miller, Hanif Salam, and Christina Kay.
Okay, well, let's start with whatever the order they apply. Cheyenne Miller?
Hi, can you hear me?
Yes, we can.
We'd like to show the Delaware Campaign for Fair Policing would like to show our support for this resolution. We know that Wilmington specifically has a police department that has been attempting to improve their relationship with the community, and it hasn't gone very well. And so we know that changing the law enforcement officers' Bill of Rights will provide for more transparency with policing, and it will provide for more accountability when policing goes wrong. And specifically would like to point out as concerns about this legislation will make discipline records of police officers public, so people can look at them. However, it would not make personal information public. And even though the community is asking for the ability for community review boards to discipline, this legislation does not do that. This legislation actually makes it so that we can give recommendations from community review boards as it relates to when an issue happens or investigation happens. It will also give community review boards the opportunity to investigate, subpoena, when misconduct happens. And so we're going to get a lot more power than we have before. And so having City Council support this is showing that City Council stands by the public and what the public isn't asking for in terms of transparency and accountability and a better relationship with the community. So we appreciate you all putting forward this resolution. We hope this resolution does pass, and that the Delaware General Assembly will listen to what the community is asking for. Thank you.
Thank you for your comments, Ms. Miller. Who's next? WITN, I can't see hands, so.
Good afternoon. Can you hear me?
Yes.
Good afternoon. My name is Hanif Salam, and I am the Smart Justice Campaign Manager for the ACLU of Delaware. I'd like to start by thanking Councilwoman Darby for introducing and sponsoring this resolution. I hope that it will have the full support of this committee as well as the larger City Council. It is imperative that we get SB 149 passed by June 30th in order for us to move forward to have an effective community review board that I know that council is already planning to set forth to my understanding, the administration has already even allotted a budget line for CRBs. And it would really be imperative for us to be able to have investigative authority and oversight authorities when working in civilian review boards, and not only just to address the deadly use of force that's being used through police departments, but we regularly see officers who abuse use of force by being way too rough with individuals that they're policing. We also have instances where people's money and properties have been forfeited, and these individuals should have the opportunity to get their belongings back. But when they don't have anyone to go to, right? They just have to call the police to try to make a complaint on the police. To have effective CRBs, our community of Wilmington and beyond, but Wilmington specifically, since we are ahead of the game with having CRBs, would have an independent body that they could voice their concerns and complaints to and know that it's going to be looked into. So I thank you so much for sponsoring this resolution. And in addition to just passing this resolution, if there is anyone on council who wants to do more to ensure that SB 149 is passed by the General Assembly before June 30, if you can connect with me, I'll put my information in the chat, because we need all hands on deck. We only have 4 weeks left in the General Assembly to get this legislation passed, and we need all the help that we could possibly get. Thank you.
Thank you very much for your comments. Okay, and the next person,
Madam Chair, we have Christina Kay.
Christina. Okay, Ms. Kay, you can proceed.
Hi, thank you, Chairwoman. I appreciate the opportunity. I kind of am just going to echo Cheyenne and Tony's comments. I'm very grateful to Vice Chairwoman Darby for presenting this resolution, and even more grateful for the City Council and your support of this resolution. Obviously, an incredibly important bill, and it is very important for the people that are working on this to know that we've got the support of City Council. So just wanted to, share my appreciation and thank the council as a whole for doing this. And then also just to echo with what Honey said, this would be importance of CRBs and making sure that the CRBs actually have the authority to be productive, to be an efficient source. So just grateful all the way around, and just wanted to make sure that you guys as a whole knew that the community is grateful for the support. Thank you.
I thank you. I thank everyone that made comments, and I thank you even more for your support. And hopefully all council members will work on getting this passed by June 30th. Any comments from council members? Okay. I didn't get a date as to which is Mr. Walker on. Can you tell me which date, what's the date for this resolution to go on?
Chairman Gray, this will be on Thursday's council agenda.
Okay, thank you very much. So this is the end of the Intergovernmental Committee meeting. Can I get a motion to adjourn?
Madam Chair,
Yes,
just before we do that, please. I can
yes,
have a comment. Thank
Yes.
you. I see that Hanif didn't get a chance to put his contact information in the chat yet. So I want to make sure that he has an opportunity to do that. And if he doesn't mind, if he can say it, if he can tell us his contact information. So for those who are watching on channel 22, so that they'll be able to contact him to to be able to help get this passed in Dover. I'm not sure if he's still on the line or not.
Yes, thank you, Council President Congo. I clicked on it. I see the chat is disabled. So my information is easy to connect with me through email. My email is hsalam@aclu-de.org. Again, that's HSALAAM@ACLU-DE.org. My phone number is 302-250-1393. And I'm open to everyone and anyone who wants to support police reform, specifically SB 149 that would amend Leopold.
Thank you very much. I will say to the public, this tape is available on the City Council website. So if you didn't get the information or you want to know more, you can replay the tape or contact Mr. Hanif, Mr. Salam. Thank you, Council President, for bringing that to my attention.
Thank you.
Councilwoman Darby?
Yes, I just want to make sure that I thank the sponsors on the state level. So Senator Lockman, Elizabeth Lockman, she's a sponsor. Co-sponsors is Senator Pickney, Marie Pickney, and State Representative Johnson, Kendra Johnson. So those are the three sponsors for this legislation. And I just want to thank them because this is a courageous move to make, and this is going to be, a challenge. But I'm glad that they took this on and are willing to use their voice and their power to say, hey, something needs to happen. We need to have this conversation. Something needs to change. And we need police reform in our state. So I just want to say thank you to the state sponsors.
Thank you. Anyone else? Any other comments, additions? Councilwoman Darby, is your hand still up? No, okay. So now may I have a motion to adjourn?
The motion to adjourn.
A second?
Second.
Thank you. The meeting is adjourned. Thanks, everyone, and I guess I'll see you in September.
All righty.
Good night.
Good night.